The families of the Idaho 4 victims have brought a lawsuit against Washington State University, contending that the school could have done more to prevent the Bryan Kohberger crime, the tragedy, and it is real. A lot of the other podcasters have spent a lot of time delving into the facts. Not here. We're going to take a look at the law and whether this lawsuit is meritorious. I'm attorney Andrew Myers. This is About the Law. Joining me as co-host, California attorney Yolie Medina. How are you, Yolie?
I'm doing well. How are you?
I'm hanging in there. When I first saw this lawsuit, I thought to myself, interesting. Don't know. I guess, if I were one of the surviving family members, I might have thought seriously about bringing such a suit, but then I had second thoughts. I don't know. We're going to get into that. What were your initial thoughts?
Well, I've handled cases like this, exactly like this. I don't know if you remember Elliot Rogers, the incel in Santa Barbara that shot up a bunch of people. Well, I handled a civil case on behalf of the families. It was at a firm, but it didn't prevail. And the reason being is because they were immune based upon the principle that if there's a duty to the public, they're immune from that. It has to be a specific duty to a person or a set of people. So when I saw this, I thought I wasn't surprised, although I thought maybe the lawsuit would be against the University of Idaho, but for not protecting their students. But I don't know if that would have been viable either. But I wasn't surprised. I thought, if you look at the paperwork at the police reports and they have people complaining about Kohberger as family, they might want to hold them accountable, and we'll just have to talk about it here and see.
Well, without getting too much into a deep dive into negligence law, 4 elements, as you and I both know: duty, breach, cause, and harm. And one of the more difficult things outside of foreseeability, which comes into the whole thing. I mean, people say it's foreseeable. No, it's not foreseeable. Well, you have to establish a duty. You have to establish that duty, whatever it was breached, that the breach of duty caused harm. And people always say, oh, causation, that's easy. No, often it's the hardest element. It's not as easy as it looks. But in this case, duty, as you raised, is the real issue, in my mind anyhow. And the duty is to whom? To whom do you have a duty? If you're out on the highways and you run a red light or you rear end somebody without any, that your duty is to the person in front of you. But the duty is to other motorists, pedestrians, whatever. But that's a defined duty. Your duty isn't to the whole world. So.
And that's also a private individual. When you're talking about a public entity, the duty gets more specific.
Absolutely. Let's take a little dive into this case, which, it was brought in the Superior Court in the state of Washington. It's now been removed. And as you pointed out to me, I think the other day, there's a motion to change the venue. I don't know why. Initially, it was removed to the Skagit County, or I should say the Western District of Washington, because where the campus is in the Eastern District of Washington. So there's a motion pending to change venue. My guess is that it'll probably be changed. I don't know. You have any thoughts on that?
Yeah. Well, I think they had to move it to that district, to the Western District, because that's the jurisdiction where you would remove it to. And then I guess they filed a motion to change venue based on forum nonconvenience. I think that's what it's called.
Yeah.
That the forum is just not appropriate for this case because everybody is in the Eastern District. And
right.
It's no burden for the plaintiffs because a lot of them are out of state anyway. So I think it will get moved.
Yeah, I would agree with you. I don't know if our viewers are that interested in the procedural stuff we spend, about you, but I think I spent 2 years studying the procedural aspect, but that was because I had every intention of going into civil law. So Again, I don't want to read all the facts, but paragraph 11 jumps right in and says, on more than one occasion, Washington State University employees would stay in a room where Kohberger was engaging with one of their colleagues out of concern that the colleague should not be left alone with him. On another occasion, a Washington State University employee told her colleague to email her with the subject heading 911 if she needed help because of their fears of Kohberger. On yet another occasion, a Washington State University undergraduate fled into a bathroom to hide from Kohberger because she was so uncomfortable with his quote unquote scary behaviors.
12. As early as mid-September 2022, WSU professors were discussing the need to do an intervention with Kohberger because of his treatment of female students. By September or October 2022, a WSU professor believed that Kohberger was stalking people. One student learned that Kohberger had photos of her and other female classmates on his cell phone.
So remember, this is alleged stalking of others at the Washington State University campus, not stalking of the Idaho 4, which we're going to get into in a minute. Kohberger's victims were encouraged to report his behavior, and a number of them did. The Washington State University Office of Compliance and Civil Rights had at least 13 formal complaints related to Kohberger, yet the individual in charge of acting on these complaints later reported that she had neither met nor even spoken to Kohberger. Now, these are things that we've really heard about. These are things that we've kind of heard about as the case went on. I think some of this was disclosed during the pendency of the Kohberger case, and I think a lot more of it has been alleged in some of the documents. And again, we're glossing over some of the facts because I think that our viewers, Yolie, don't you think a lot of our viewers have heard a lot about this?
Yeah, they've heard about it, and the fact that the civil rights person, they don't name anybody, the fact that the civil rights person in charge of investigating didn't talk to Kohberger, that goes to whether or not that person thought the complaints were of a severe nature in order to talk to him. Maybe they weren't. I don't know. The complaint is kind of vague as to that because they talk about several faculty members, employees, but they never say who. So, and they talk about female students, but they don't name who. And I think they're going to have a hard time getting discovery on these students because their information is private. So
yeah, I mean, all right, let's put on hats here. Let's put on hats. I'm the personal injury attorney, and you're representing the university. We can switch hats in a few minutes if you like, but I'm coming after Washington State University on this complaint. I'm the attorney, and you're representing Washington State, and I say, okay, it says here that a woman was afraid of Bryan Kohberger. It says here that a woman thought that Kohberger was following her out to her car, or actually observed. I ask you for the identities of those people. Now what? What are you going to do?
Objection, FERPA.
Yeah.
And that's that's why Catherine Ramsland couldn't speak out about Kohberger because of FERPA. And that protects students. It protects students' records. So to the effect that this woman complained, her complaint is protected. Now, I'm not saying they will never get it. The plaintiffs will never get that information. It's just going to be very difficult. It's going to be a lot of law in motion. There's going to be protective orders. This woman may not want her information out there. She may not want that. And so it's going to be a problem if this person doesn't want their information out there because she's not going to she's not going to want to help them if she doesn't want her information out there. So it's a tricky situation.
It's something that the court is going to have to resolve. I mean, you're going to say, FERPA, I'm not going to give it to you, Attorney Myers. And I'm going to say, well, I'm going to file a motion to compel because whatever argument I made. So it's up to the judge. It's up to the judge. But there's going to be a lot of motions like that. There's going to be a lot of issues like that in discovery because there are many, apparently, if you read through this complaint and through the allegations that we've talked about before. And when we read over some of the documents, we've read over it. before. I want to jump ahead to paragraph number 22.
It was against the above described backdrop of WSU administrative inaction and police dysfunction that Kohberger arrived in the Pullman, Moscow community, immediately began engaging in overt harassing, stalking, and predatory behaviors, including repeatedly stalking over a period of months the 4 victims that he ultimately emmed on November 13th, 2022.
Wait a minute, hold on. I thought there was no stalking. I mean, immediately began engaging in overt harassment. Now they're mixing two things together. They're talking about how there was dysfunction with Kohberger when he arrived in the Pullman, Moscow community. But then they're talking about he immediately began engaging in overt harassing, stalking, and predatory behaviors. Okay, so that part of the sentence seems to me to be stating that this happened in Pullman, Washington, on the campus of WSU. But then they sneak in the end of that sentence, immediately, repeatedly stalking over a period of months the 4 victims that he ultimately murdered on November 13th, 2022. There's no facts. And in fact, I'm going to play a video right now of the police officials on the day that Bryan Kohberger was sentenced, admitting outright that there was no stalking. They had, as much as they tried to get evidence of stalking, there was none.
Well, I think Darren and I have, the evidence suggested that there was a reason that this particular house was chosen. What that reason is, we don't know. We don't know who the target was, and we're not going to speculate on that up here today. But we can tell you that for whatever reason, Mr. Kohberger chose that residence. Perhaps it's the location, layout, we don't know. We've looked for a link, and we have not found one, not one.
Yeah, through the entire investigation, I think that's something that we need, that you want, is to help to understand this and say, well, what's the connection? What was the link? And so we had every resource possible, and we worked that tirelessly, both from everything from his side, but all the victims and all the members of the house from their side. So we have never, to this date, found a single connection between him and any of the 4 victims or the 2 surviving roommates.
Okay, so someone else has a question, but it's not relevant to what we're talking about. Don't you find that a little bit odd that the complaint comes right out and says he was stalking the 4, and the police officials, the investigators themselves say, no stalking?
Well, yeah, and I think that the plaintiffs, I'll put my plaintiff's hat on now, that
Okay.
that the phone pings that were near the house 23 times, that is what is going to be used as stalking. And for a civil case, the burden is lower. But I'm not sure that that would rise to the level of stalking, because later on, Bill Thompson in that press conference says, you know, we just pinged him to a cell tower near the house. Okay. And there's plenty of homes around there. So if that's what it is, that he pinged to a cell tower near the house 23 times, there could be other reasons why he pinged there, because the shopping's better. He would go there, to shop, or he, whatever reason, he would go there to cross state lines to Moscow and just pick up items or, do things. And so even for a civil case, I'm not sure that it would rise to, more likely than not that he was stalking them. But that's the argument.
Right. No, you just argued both sides of it. I was going to take the other side of it. You just argued the side that, as the plaintiff's attorney, you would say, sure. And that's what they did say. Well, he pinged the cell towers that service 1122 King Road, what was it, 21 times or something like that. Doesn't make any difference, really. And I would come back. Now, I put on the university's hat and I say, so what? And you already answered that. And I would bring in, and at one point we talked about an expert that was in that area that said the range of that cell tower or cell towers covered all the things that you just said. So so it's an argument I can't see the jury buying it. I really can't. What I'm saying here is it seems that if they're willing to be so flexible with the truth there and just come right out and say, including repeatedly stalking over a period of months the 4 victims that he ultimately murdered on November 13th, in my mind, that casts some doubt on all the facts that are in this.
Well,
complaint.
all
They have
4
to
of
prove
the
it.
victims, it's like all 4 of the victims he stalked, even Ethan. So he was stalking all 4 of them.
That's what it says. That's what
See,
this
that
complaint
means
says.
that he was following them around. He was watching them, following them around. And according to Idaho law, the person has to be aware that they're following, that someone's following them, a specific person, in order, to have that effect. But let's say he was surveilling them. He was surveilling all 4. I mean, we do know of an instance where Kaylee was at a supermarket and there was 2 guys following her and they followed her out to her car. That was not Kohberger. That was some other people.
Right, exactly.
So we don't have anything like that with Kohberger. So I don't know. I think I don't know what to say.
Well, I do know what to say. What I say is that you have to be careful when you draft pleadings because none of the plaintiffs themselves signed this, but the attorneys did, and in federal court where this ended up, we have a Rule 11 obligation to have read everything as though we wrote it ourselves, and that it's all in good faith. So I don't see where the good faith basis for that is, and it's not a minor point. It's not a minor point, and the reason I'm saying it's not a minor point is that this complaint comes right out and says, A, stalking is a serious and prevalent risk to college students. 38, stalking is a serious and prevalent threat facing college-age young adults, both on and off campus. And that's true. I have no beef with that, but this is kind of general. This is like a magazine article on stalking. And, university students, administrators, faculty, and everybody should know all this stuff. But in my view, it really has no part in a complaint where the lead prosecutor himself in a hearing in open court way back when the case was in Ladau County said there is no stalking. So one more thing before we're going to get into the law and how I think that the law underlying this complaint is questionable. I wanted to go to paragraph 128. And Yolie, with your mental health background, I wanted to point out something that really stood out to me. As I went through this complaint. Here we go. Paragraph 128, WAVR. And we decided that WAVR stands for Workplace Assessment of Violent Risks. So this is one of the things that's in the administrative manuals. And it says that this workplace assessment policy further warns that autism spectrum disorder is a risk factor for young perpetrators of mass murder due to their strong desire for, but inability to establish intimate or social bonds. And I said to myself, what? What are your thoughts, if any?
Well, my thoughts are that I know when initially Bryan Kohberger came out, the report came out that he was on the autism spectrum. People said he's lying. That's not true. He's just trying to get out of the death penalty, blah, blah, blah. And then they bring it in this complaint, which is kind of indicating that Washington State University knew he had autism spectrum disorder. Otherwise, why put it in the complaint? So if Washington State University knew that Bryan Kohberger had autism spectrum disorder, then you're dealing with a disability. And again, under FERPA, when you're dealing with a disability, and I'm not even sure if it's FERPA, I think it's just the ADA, Americans with Disabilities Act.
Yeah.
You're dealing with somebody like that in the workplace. You can't assume certain things. I mean, you got to go through the channels and go through and try to work it out with him. I mean, I don't know. I think this threat assessment is more likely to be a decision-making tool that helps, the employers make decisions, and they weigh the risk factors. And so to me, that sounds like they're using discretion when they do that. So if it is that, and then it might fall under the discretionary immunity. I don't know, but we have case law that you're going to talk to us about from Washington State, right?
Yeah, we do. We do in a minute. We're going to get to that in a minute. There's some case law in Washington State that goes against this entire complaint, but this stood out to me as one of those things that said, the complaint itself doesn't make out a very good case for recovery for the survivors of the Idaho 4 victims. And the reason I say that, we already talked about the stalking, and there was no stalking. So, that casts the other allegations into doubt. And to say that there's a warning that autism spectrum disorder is even a risk factor for mass murderers, I shake my head at that because, I'm no expert. And I've told you this before. I have a Psych 101, 201 knowledge of psychology. So I have enough knowledge to not know anything. And I admit that. And at the same time, just as a general observer and someone who's read a lot and listened to a lot and seen a lot, those with autism, come from all sorts of areas in life and society, in the abilities they have, the things they can do. Some of them are very bright and go on to achieve great things. And the only thing that comes to mind, and I can't remember, comment down below and tell me one of the great musicians. I don't know whether it was Mozart or Handel. I don't think it was Handel because he was pretty political, but one of the great musicians who has left us a ton of classical music in analysis has, they have said in retrospect, might have been Tchaikovsky. In retrospect, they thought that one of these great musicians who produced tons of great music that many of us enjoy was autistic because of his lack of social graces and his inability to really get along socially, but also because of his, I don't want to say OCD, but his precision in the way he put music together and could put, So my point is, there's got to be a better risk factor for figuring out spectrum disorder. So, okay, enough of that. Obviously, I'm not an expert in psychology or music, but I mean, those things stand out to me. So what are they really, really looking at? What are the causes of action here? So bear with me while I go to the bottom. And
yeah, and the pictures, I'm not a fan of that. I don't put stuff like that in the complaints. It's just not.
I have, but it's rare. I have, but it's very rare. I have put photographs, but now this photograph we're looking at now, we've been looking at this photograph for 4 years. And yeah, to put it in a complaint, I don't know. It's not written for a judge. It's written for content producers, I think. Don't you?
Well, yeah, it's you're supposed to allege facts, and these photographs and images are not. There's no foundation for it. So,
there's no place. I agree with you 100%. I mean, when you go to a trial, even that last photograph that we showed, we know who they are. We've seen it many times. We have sympathy for them and their families. Please don't take anything that we say here. This is a legal channel. Don't take anything we say as having lack of empathy for the families who brought this lawsuit. This is a legal analysis. But, for any photograph at all, including the last one, you've got to lay a foundation. You have to show that it's authentic, and it'd probably be pretty easy. But I agree with you, Yolie. I don't think there's really any call for it. I think I've written one complaint where I put pictures in, and I can't recall what it was. I have no idea. Okay.
And also, too, I've handled cases like this. I feel for the families. I do. I mean, I've handled cases that have been lost because they were immune because of the public duty doctrine or some other discretionary measure that they had to take, and it's sad because these families see these police reports, and I mean, what do they think? And these women could, I mean, the people in the complaints that are in the police reports, it's like hearsay upon hearsay. They may be exaggerating, knowing that Bryan Kohberger was found, was arrested, and they may now be looking back and exaggerating what they thought that, but I don't know anything. I mean, we're just analyzing this legally and clinically. Just
All right. Speaking of legal analysis, let's forget the facts. Let's just forget everything. For the purposes of a legal analysis, though, let's just assume everything they said is true. Let's assume that absolute everything is true and that they can prove that Bryan Kohberger was stalking all 4 of the victims. Just for the sake of our legal analysis and for the rest of this episode, let's assume it's all true. What are they suing for? What are the legal counts? You can't just file a complaint and walk into court with your checkbook. You gotta have some basis. All right. We attorneys categorize the basis for recovery into what we call counts. There are a bunch of them here. Count 1, violation of Title IX of the Education Amendments of 1972. Okay, Title IX, you can probably explain it better than me, but Title IX was civil rights legislation that was meant to enforce the laws against any type of discrimination in the schools. And so it was meant to straighten out any discrimination in the schools. And yes, there's a right of a civil action under Title IX. Generally speaking, however, that right of action is to encourage the schools to give equal protection under the laws to all of those in suspect classes. Whew. Did I say that right? Okay. But that's generally what a cause of action is under Title IX. I think it's a stretch, in my opinion. I think it's a stretch to use Title IX, which was intended to recover for breach of the duty to, have equal rights in the schools. Okay, so that's count 1. Do you agree with that or not? You can not agree if you
No,
want.
I agree. And, sexual harassment is considered one of the biases that Title IX is supposed to remedy. And if you don't have that harassment or the stalking, then Title IX, it doesn't work. But Title IX, it goes to the duty. Like Washington State University had a duty to its students, right?
Right.
Well, does that include the Pullman, Washington area?
Oh, let's get into that in a minute. Let's just take another look real quick. Let's take a real quick look at the counts here. Negligence is what you just said. Duty, breach, cause, harm. But who is the duty to? Is the duty to only the general student body? Or does the duty go out to the third parties across the border over in Moscowidaho? And we're going to get into that in a minute. But that's what this count is. They're saying that Washington State University had a duty to protect the Idaho 4. They breached that duty, and as a result, it caused Bryan Kohberger to do what he pled guilty of doing. So that's the negligence count. The next count, gross negligence. Plaintiffs incorporate by reference each and every allegation stated above. We all say that. So we don't have to repeat everything. Washington State University had a duty to exercise slight care, which is care substantially less than ordinary care, and to refrain from grossly negligent acts or omissions. There are multiple failures and breaches of its duties owed. So this is a piggyback count. That's what we call them, I think.
Yeah, but owed to whom? That's the thing.
Right. We're going to get to that. You're right. Keep hammering me on that to remind me to get to that. Okay. Count 4 I thought was interesting. Is this really a count? I guess it is. Outrage. The cause of action for outrage. And they're saying, we incorporate everything else that we said in here. Washington State University's acts and omission described herein constituted extreme and outrageous conduct that went beyond all possible bounds of decency and can only be regarded as atrocious and utterly intolerable in a civilized community. Well, that certainly, paragraph 483 would certainly go to what happened on the night of November 13th, 2022. No argument from me at all. But does that outrage relate back to the conduct by Washington State University?
Well, and the outrage goes to the emotional distress in that, is it emotionally distressing for these parents to read reports about students complaining about Kohberger and all these crazy things, and they did nothing to stop him? I mean, with that, you can think, oh my God, no wonder they're filing this suit. But when you go deeper, there's several layers of hearsay, and all of those reports were after Kohberger was arrested. So you don't know how that affected the people that are making the reports. And not only that, there were intervening factors that occurred. Okay. Number one, he crossed state lines. Number two, there were other people who were there in the house who did not call 911. There were acts on behalf of the possible victims that may have put them in danger. We don't know what Washington State University is going to raise as intervening causes.
I think what you just said, you really hit the nail on the head, and a lot of people find it hard to understand. We're not going to get into the Palsgraf case, but you've got to. We could, but we'd be here for an hour.
That's California, the fires that keep going.
I thought Palsgraf was New York. I thought it was the New York Central Railroad that
right.
Party.
But the fires, it had to do with the fires, right? The pole and the.
Well, yeah, you people in California used that, but what I'm trying to get to is, let's assume there's negligence. Let's assume, for the sake of this pontification on my part, let's assume that there's negligence on the part of Washington State University, and Bryan Kohberger marched into the bursar's office and said, I'm going to go over to Idaho and off those 4 kids. Let's assume that happened, all right? What is the duty? What is the duty, and to whom is the duty? And it's not an easy thing. My hypothetical, probably pretty easy, but here's the thing, there are intervening causes and superseding causes. In other words, what happened after Washington State University's negligence and their negligent acts, there might have been something else. And the question is, that's an intervening cause, but if something else happened, then that's a superseding cause, and the initial negligence of Washington State University doesn't apply. And there was at one time a law, which I've actually argued to a jury successfully, but it's been circumvented. There was a law that even if the initial actor is negligent, the criminal conduct of a third party supersedes that and cuts off the original negligence. In other words, if Washington State did something bad and negligent, and even grossly negligent, the criminal conduct of a third party in some circumstances will cut that off. So
in California, just let me tell you,
please,
it doesn't cut it off, but it creates a percentage of liability. In other words, for example, social services, if they fail to protect a child, the unalivers, who probably were the mother's boyfriend and the mother, they're the ones who actually caused, they bear the majority of the responsibility. But social services would have a portion of liability for that, for not taking the child out of the house, which would have prevented the parents from unaliving her. But here, we have no relationship between the Idaho 4 and Washington State University that we know of.
Yeah, that's the law that I'm familiar with now also.
Mm-hmm.
That's the law I'm familiar with now also. But I think that this lawsuit is in trouble. And here's why I think that this lawsuit is in trouble. Here's a case that the people in Washington State University should be very well aware. Let me see if I can make it just a little bit bigger for our people to see. How's that? Okay. This is a case that went up to the Washington State Supreme Court. And this case involves 2 questions that were certified to the court. This is the big kahunas in Washington. This is the top court in Washington. So this is the law in Washington State, and the federal courts follow the state law. So this is the law in the state of Washington. Plaintiff Madeline Barlow moved to the Washington State University main campus in Pullman, Washington in August 2017 to start studies as a freshman. August 20th of 2017, Thomas Culhane, a fellow WSU student, assaulted her at a party that she attended at his off-campus apartment. Culhane was expelled from WSU and was later convicted. Culhane had been a student at WSU's Vancouver campus until spring semester 2017. While there, WSU received 2 complaints of misconduct against Culhane. One student made a complaint that Culhane sent her S comments via electronic communication. Another student reported that while on a university bus for a school trip, Culhane sat next to her, put his hands on and between her legs. He continued even when she told him to stop. The student reported the events to the school, and the Office of Student Conduct conducted a hearing and found Culhane responsible for violating student conduct under their rules. Discrimination rules, misconduct rules, harassment rules. During the investigation, Culhane requested to transfer to the Pullman campus, which was granted. So they just moved him around. Sounds like a certain religion that plays. Oh, let's not go there. Let's not go there. As a result of the hearing, although we could go there, as a result of the hearing on August 1st, 2017, WSU suspended Culhane for 9 days and assigned him to write a paper on his understanding of consent. You know what that reminds me of? That reminds me of in 7th grade, I flunked a spelling test and they made me stay after school and write words out 25 times. By the way, I still can't spell, but anyhow, on January 28th, 2020.
Oh my God, that's crazy because I was a spelling bee champion.
Well, I could, to this day, I look words up. To this day, you know.
Well, now I do. Now I do.
But I mean, so that's the punishment, write a paper and you know, we're done. Okay. On January 28th, 2020, Barlow filed suit against WSU in the Superior Court for Thurston County, bringing a number of claims, including most relevant for this analysis, a claim for negligence. WSU removed the case to federal court. Sound familiar? Mm-hmm. Barlow's negligence claim rested on WSU having a special relationship with its students, alleging a duty to both control and protect the students with the knowledge of Culhane's past S misconduct, making the harm foreseeable. WSU motioned for summary judgment, arguing that Barlow's claims failed as a matter of law because her injury occurred off campus. Interesting facts, where the school had no control and no duty. The district court granted the motion for summary judgment. Barlow appealed to the Ninth Circuit, and that court certified the 2 questions regarding the negligence claim. The questions were: 1, does Washington law recognize a special relationship between a university and its students, giving rise to a duty to use reasonable care to protect students from foreseeable injury at the hands of other students? And 2, if the answer to question 1 is yes, what is the measure and scope of the duty? So these are the questions you were asking before, Yolie, and we didn't talk about this before. Do you want to read a paragraph? Then I'll read a paragraph.
Sure.
Okay,
sure. The analysis. This court may answer a question of law certified from the federal court if the question of state law is one which has not been clearly determined and does not involve a question determined by reference to the United States Constitution. Certified questions are determined de novo. That means new. The questions are not considered in the abstract, but based on the certified record from the federal court.
So while the facts establish the context of the underlying case, the certified questions here involve purely legal determinations. So here's where it's going to be very relevant to the Idaho 4 case. The certified questions focus on duty. The determination of whether a duty exists is a question of law, which is reviewed de novo, all new, as Yolie just said. When considering whether a duty exists, this court weighs considerations of logic, common sense, justice, policy, and precedent. And they cite to a 2004 case. Guiding our determination involves reference to the principles reflected in what we call the Restatement of Torts. Restatement of Torts is a huge document that generally embodies common law, and it sets out various policies in the law. Not every state follows them, but many states elect to follow them, and I guess they're looking at the restatement to determine whether Washington should follow this. Your turn.
The general rule is that people and businesses have no duty to aid or protect others from harm, and they cite the Restatement of Torts. Second, So the restatement of torts acknowledges the same general rule that there is no duty to protect others from third-party conduct, but outlines 2 exceptions, including when there is a special relationship, which means that a relationship exists between the actor and the perpetrator, or between the actor and the plaintiff/victim.
In this case,
So-
Barlow. I'm sorry. Go ahead. Go ahead.
No,
what were you going to say?
yeah, so special relationship is a legal term. We'll get into that.
Okay. Barlow argues that such a special relationship exists between students and universities and asks that we expand the common law duty of kindergarten through 12 schools to university. So, in other words, when you go to school from kindergarten through 12th grade, you're compelled to be there, at least until the age of 18. You got to be there. And so they have a duty to these kids. When you're in college, the question is, does the college really still have that same duty? And the restatement apparently raises the question that to establish that Washington State University had a duty to both protect her and control Kaylee, and this court says it has never recognized such a special relationship and duty between a university and its students. Rather, the proper analysis can be found in a different section of the restatement.
Okay, the restatement of torts recognizes an exception to the general rule relevant here, which the state acknowledges exists. A possessor of land who holds it open to the public for entry for his business purposes is subject to liability to members of the public while they are upon the land for such purpose for physical harm caused by the accidental, negligent, or intentionally harmful acts of third persons or animals, and by the failure of the possessor to exercise reasonable care to A, discover that such acts are being done or are likely being done, or B, give a warning adequate to enable the visitors to avoid the harm or otherwise protect them against it.
Under this rule, a university, as a business operator and possessor of land, owes a duty and would potentially be liable to members of the public, including students who are on campus for school-related purposes. Note those words. And the court is saying that this section of the restatement creates a type of special relationship, but the duty is limited to university property and activities controlled by the university. And I always tell people, go down in the footnotes, because this is a key one, folks. This section of the restatement of torts also recognizes that all schools, including universities, have a special relationship with their students. However, comment I from that section states that, as with the other duties imposed by this section, it is only applicable to risks that occur while the student is at school or otherwise engaged in school activity. So I don't know if you remember earlier on in this episode, I said, if there is a duty, and if everything that we've read and beyond is true, that Kohberger was exhibiting all kinds of antisocial and, outrageous conduct, and they were on notice to do something, that duty would extend only to the people either at school or otherwise engaged in school activities, such as the things I talked about before. If there's some kind of an evening class or a social meet and greet or some kind of a seminar. So that's what they're saying here. The duty would be limited.
And hazing, when there's hazing allegations, I know there's a case in Washington, and I can't remember the name of it, but Washington State University was held liable for the hazing death of a student, which occurred at a fraternity house. And it happened, I believe, at the fraternity house. So yeah, it's when things happen off campus, it's really difficult. If not, it's almost impossible to try to allege something like this, that, they had a special relationship. And one thing is, this is why it was so confusing to me that the president of Idaho State University was involved in the investigations, or at least getting, information from the police, when this incident did not occur on school property.
Yeah, it raises a real issue, and the legal view of it all is, what's the duty? Is the duty to the whole rest of the world? How far
Public
is
duty
one
is
to?
not,
No.
they're immune from public duty. A duty
So
to the public. Yeah,
right.
I'm sorry. Go ahead.
No, it's fine. Barlow first asks that we apply the duty to protect students established under our cases between K to 12 schools and students and expand that duty to universities. So this is kind of a sidetrack, but let's go down it. Our cases have developed a common law duty and special relationship with reference to the restatement between K-12 schools and their students, but no basis exists to expand that same level of special relationship to university. So you see, they're stretching already just to hold this special relationship that the elementary and high schools have. They're already kind of straining to apply that duty to universities, but they do go down that road. No basis exists to expand that same level of special relationship to universities. The duty of K-12 schools stems from the school's care and custody of the student, the fact that the child must attend school, and the relationship is not voluntary. Get on that school bus, kids. And the protective custody that teachers undertake being a mandatory substitution for the parent, which is true. If I acted up in class, the teachers sent home a note to the parents, so they knew. Anyhow, our cases rely on the nature of the relationship where K-12 schools have almost complete control over their students and their activities to establish that duty. K-12 schools generally operate as closed campuses, with the school monitoring closely all who enter the premises. A K-12 school has more ability to exclude members of the public as a safety precaution. Students' time on campus is carefully structured, controlled, and monitored, and they have little choice in class offerings. K-12 schools control their young students and are standing in as parents during the school day, and that control gives rise to the duty that those schools owe children. That same control and relationship does not exist in a university setting.
Universities do not have similar protective custody over their adult students. And I'm just going to stop right here. It's like when an officer has a suspect in custody and they're handcuffing them, there is a special relationship there because they have protective custody over that suspect that they're arresting.
Right.
Then it goes on to say university students are not under the complete control of the university or otherwise dependent in the same way as K-12 students. Universities do not have mandatory attendance. University students have the ability to choose how to spend their time. The student can decide whether they will attend class in a traditional setting or online. The class hours are often limited, and when not in class, students spend their time as they wish. They can take part in extracurricular activities, work, live independently, marry, take up hobbies, and choose with whom to interact. A university is distinct from a K-12 school lacking the requisite control over the students' decisions.
So there's a real big difference between K-12 and a university. You don't even have to go to university. A lot of people don't, and some do very well. And you can have a hobby, marry, do whatever you want when you're in college, and most of us did. Barlow proposes that we look into another section of the restatement 315B to establish the special relationship and a duty of a university to protect its students. Though we have recognized special relationships and broad liability in some contexts, the cases do not support applying the duty of that section to a university. Our cases have identified the nature of a restatement 315B special relationship giving rise to a duty under limited circumstances. For example, in the case of Nice versus Elmview, we held that a group home had a special relationship. Okay, I can see that. With a vulnerable adult in its care, based on the fact that Nice was totally dependent and unable to care for herself, and Elmview was fully responsible for her care. That responsibility gave rise to a duty to protect her from a wide array of harms. Elmview's control was critical to applying the duty. That level of control simply does not exist here. Ms. Barlow was not a vulnerable adult lacking the facilities to care for herself. The university had no power to control her decisions or actions away from campus. The existence of a Section 315B duty requires control over a vulnerable person's actions, essentially a complete dependence in order to live.
We have more recently explained what creates a special relationship and rejected an invitation to broaden the common law duty. In Turner versus the Department of Social and Health Services, we stated that restatement second creates a heightened duty to protect someone in a situation where that person is helpless, totally dependent, or under the complete control of someone else for decisions relating to their safety. The duty is not based on custody, but on the dependence of the victim. Where this type of special relationship is formed, it is accompanied by a heightened duty of care to protect the person from any foreseeable harm, equating that duty to strict liability. If the relationship lacks the traits of dependence and control, we held that no liability exists. No similar duty exists between a university and its students under which a special relationship is implicated. The court expressly recognized the limit of the special relationship, stating, "We conclude post-secondary schools do have a special relationship with students while they are engaged in activities that are part of the school's curriculum or closely related to its delivery of educational services." The court went on to further define the scope of the duty. The special relationship we now recognize is similarly limited. It extends to activities that are tied to the school's curriculum, but not to student behavior over which the university has no significant degree of control. And it cites the regents. There is generally no duty to protect others from the conduct of third parties. The special relationship doctrine is an exception to this general rule. Accordingly, as a consequence of the special relationship recognized here, colleges generally owe a duty to use reasonable care to protect their students from foreseeable acts of violence in the classroom or during curricular activities. The limitation applies here and is consistent with our cases recognizing the scope of the duty.
And so an assertion is made that because a university is involved in aspects of student life outside the academic sphere, such as providing basic necessities, it is acting as a guardian or in the place of a parent. But the examples of non-academic offerings noted, on-campus housing, providing food, opportunities for social interaction, generally occur on campus where a university has potential liability based on Section 344. Also, it is argued that because a code of conduct exists, that addresses off-campus behavior. The university is taking measures to control that behavior, and its duty should also extend off campus. We disagree. The code of conduct does not create a control of students' behavior in a preventative way. The code may provide the university the ability to academically punish students after the fact with suspensions, academic probation, or even expulsion. The code of conduct is irrelevant to the establishment of a duty.
While S assaults are horrific, a university simply has no power to dictate students' movements off campus and away from the oversight of campus security and administration. While a special relationship exists between a university and its students, that duty is to use reasonable care as recognized in the restatement second. Because no ability to control off-campus, non-school sponsored interactions exists, the duty does not extend to the choices or activities under a student's control. A university's duty is limited to where a student is on campus for school-related purposes or participating in a school activity.
Conclusion, we answer the first certified question. Yes, a type of special relationship exists, but that relationship is defined and anchored in Section 344 of the restatement. The duty exists where a student is on campus. Similar to a business invitee, the measure and scope of the duty is based on a student's enrollment and presence on campus or participation in university-controlled activities. So now, to be fair, there's a dissent, but the law is stated in what we just said. So let's back up a little bit. Correct me if I'm wrong. What this case says, and also you would think that the university would be very well aware of that case because, you know what, it was against them, so they would have known. But I think what the case says, and correct me if I'm wrong, under the facts alleged in the Idaho 4 victims' parents lawsuit, the university may well have had a duty to do something more affirmatively with Bryan Kohberger while he was a student at that university. It's arguable, but maybe they didn't do enough. Maybe they should have gotten rid of the guy. I don't know, but the duty does not extend to the students over. I'm not going to say over the state line, because they've made a big deal out of, and I think we know why, the fact that it was a community, the Pullman, Washington community. They're trying to, I think they know that this case law exists. Maybe not. I think they know that this case law exists, and the duty doesn't go beyond either one, the university itself, or two, university sponsored activities. So that's why they're trying to compress this into a community. I don't know. Did I say that right?
Yeah, I think you nailed it. But yeah, and the one thing that I think about, and I don't know, is if Bryan Kohberger was engaging in some type of project with the Washington State University and Pullman Police Department that somehow had some kind of educational thing with the Moscow Police Department, and he was doing something for the school in that regard. But even still, I don't think the special duty would apply, but at least it would be some kind of related project that he was doing with Washington State University and the University of Idaho. But I don't see that he was doing that. There's no evidence that he was doing any of that. But you never know. Something might come up that might show that he was doing something, and I don't know how the special relationship would apply then. But aside from that, I don't see it, especially with this case law, the one we just went over, because I know there's case law, and there's also case law on foreseeability. I mean, duty, you have to get past duty first. Assuming you get past duty, then there's foreseeability, the causation and foreseeability. So anyway.
No, I see what you're saying. I went to college in Boston. I went to Emerson College, and there were a lot of colleges in Boston. I can't, a dozen, must be more, including Cambridge. I mean, I don't even know how many colleges there are, and they're all within, if not a walking distance, a quick hop on the T, which is what we call the the transportation. I would laugh to call it the mass transportation, but anyhow, or the speedy transport. My point is, we had inter-campus activities. You could go to another campus and participate in certain things. For example, I went to Emerson, and back then, I'm not going to say what I'm thinking about their library, but we were allowed to take the Green Line up to Boston University and use their Buger library, which I did all the time. So, but if there's anything like that in this case, no, it didn't exist. I mean, don't you think we would have heard about it if Bryan Kohberger was allowed to go to the campus up there to participate in some seminar or class or library or whatever? We never heard about that. So
no,
the facts in the case, they're really a stretch. One of them, and it was in paragraph 243. Well, right after Mr. Kohberger got to Washington State, he went to a pool party and he made some of the women uncomfortable. Well, okay, and that comes right out of Howard Blum's book, and there are a lot of other things in this complaint that we didn't spend our time reading over the complaints that he made people feel uncomfortable. There were complaints, people felt creepy with him and all of that, but taken in its entirety, I can see what the plaintiffs in this case are trying to do. Taken in its entirety, the people, the administration, the faculty, the supervisors at Washington State, were on notice. So they're claiming they were on notice, and that may well be, although how many of them were at that pool party where he made women uncomfortable?
And the pool party was off campus.
Right.
And how would Washington State University know about these women who were uncomfortable at the pool party?
Well, it's all surplusage, the way I see it. That's what the courts call it. They call it surplusage. That's a nice way of saying something else that I think our viewers know what I'm saying. I mean, the complaint was really padded out. There was a complaint one time in Massachusetts, and I mentioned this in a previous episode. I forget how many pages it was. It was very, very, very long, and the court dismissed it because it was prolix, which is a nice word. So I think what the plaintiffs are trying to establish, and are they going to bring in all of these people? Are they going to bring in all of the women? This gets back to what we were saying in the very beginning. how are they even going to identify all of these people?
Well, and in federal court, you're limited. I think it's 10 or 8 depositions that you can take without leave of court. Then you have to get leave of court. Then if you have to depose a prisoner who's not a defendant or not a plaintiff, I'm sorry, you have to get a court order. And it's very, I like federal court too, like you, because it's very structured. But it's difficult for, a huge case, like an elder abuse case. I remember I had one where it was based on diversity, and I was able to get it remanded back because they had minimum contacts in California. But it's very limited. You can't. You gotta be very narrow in what you're trying to achieve, and the complaint is not narrow. It's kind of all over the place. And I sympathize with the families. I empathize with the families because I've talked to families who had cases like this and who felt badly and wanted to do everything they could to hold everybody accountable. Sometimes it's not possible.
It's horrible. Yeah. Anytime you sue the people that run our government, you're going to have a hard day because there's a lot of
Always.
procedural hurdles,
Immunity.
a lot of legal hurdles. And one of the thoughts that I had, and I've heard some other people talk about that I don't think is likely. Well, what's the likelihood that the university will just settle it? No. We talked about the 2 bars in the Karen Reed case, and a lot of people, and I disagree with them, but a lot of people are saying, oh, won't the bars just, give them some money to make the whole thing go away? Won't they settle it? A, I don't think they will. B, I've handled cases successfully for dram shops, and it's very hard for plaintiffs to prevail on those cases. But B, those are private parties. And those bars, either they have to pay for their own attorneys, or the insurance company has to pay for attorneys. And insurance companies don't want to pay anything more than they have to. They're measly. They'll delay, deny, and defend against everything they can possibly delay, deny, and defend against. So they don't want to pay. The difference here is that Washington State University is part of the state. They have deep pockets.
They're self-insured. They're self-insured, mind you.
Well, but they have deep pockets. They can sit there and shell out the attorney's fees as much as they want. I mean, they don't care.
That is true. It's a resources that the public entities have. Yes. They have a lot of resources. And I know here it's the UC Regents. That's the UC, the University of California, Irvine, UCLA. It's the Regents. And, they have a whole board that approves everything. And so you have to go through a lot of red tape to finally get something approved for a settlement to begin with in California. So I imagine Washington has some kind of the same setup, but they're self-insured. And so when they have a self-insured retention policy, you're not dealing necessarily with an insurance company.
Oh, no, they have the Attorney General of Washington has just stepped in. The Attorney General of Washington State has just stepped in. So they've got skyscrapers full of attorneys in Seattle and probably also out in Spokane. They've got, skyscrapers full of attorneys that are going to get paid whether they're sitting there reading the paper or going to court defending this case. So it doesn't make any difference to them. So my answer to those who say, oh, they'll just settle it, I doubt it.
Correct.
Wrong,
that's correct, because the attorney generals get paid no matter what.
Right.
And so it's not, and for people, I know people have had questions, 2 questions that have come up, and I'll just answer them real quick. Okay. It's not uncommon for the attorney general to step in a civil rights case against the state. It's also not uncommon for the city attorney to defend a civil rights case, like a police brutality case. It's not uncommon. There's nothing suspicious about that. Right. Sometimes they hire private counsel. Sometimes they don't. The other thing is anybody can file a complaint. It doesn't matter. I could file a complaint against Andrew Myers and allege all of these crazy things that Andrew Myers did this, that, and the other. And I can file it in federal court in allege diversity and say Andrew Myers, blah, 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 blah. It could all be lies and it could be filed. The clerk of the court does not have the ability to reject the complaint. I could file a bunch of lies. And then it would be up to Andrew Myers to come back and just get, relief.
No,
right?
what I would do is, and I can't remember the context. I was thinking of this. I can't remember the context, but I have two choices. If Yolie sues me for being a belligerent co-host and being rude to her, if she sues me, I have two options. Well, doing nothing is always an option, but put that off the table. I have two options. One, I can answer. She has to put individual specific allegations in enumerated paragraphs. So now I can deny them all. I can deny everything. Or instead of answering, I can file a motion to dismiss. And I've done that in the past. I can file a motion to dismiss. I forget what case it just happened in. Oh, the Karen Reed case. I think in her case against the House defendants. Two of them, including they're not House defendants anymore. They're the Commonwealth witnesses. They filed a motion to dismiss. And wasn't Proctor, wasn't Tully, but one of the three officers that was named also filed a motion. So those are your two options. You can answer, which will happen in this case probably, or you can just file a motion to dismiss. And a motion to dismiss says, as I would say to Yolie's complaint, even taking all the things that she said, even so, and drawing all positive inferences, she's failed to state a cause of action on which relief can be granted. So I would guess, I believe that the Idaho 4 victims' parents have at least even taken all the facts that you disagree with, but for the purpose of a motion to dismiss, if you agree that they're all true, that they have stated causes of action. Maybe not the outrage count, but the other ones, I think they've probably stated a cause of action. However, after discovery, I would guess that a motion for summary judgment would be coming down the pike. I don't know.
Well, it might even get tossed on a motion to dismiss, but just because there's a motion to dismiss and it gets granted, that doesn't mean that the court wouldn't allow them leave to correct the complaint, right? So
Sure.
They can allow them leave to clean up the complaint. It happens more in state court than federal court, but the plaintiffs can ask for leave to amend. In other words, if the court is inclined to grant this motion to dismiss, plaintiffs request leave to amend the complaint and give an offer of proof as to how they would amend it. Right. But that happens in state court a lot, but I don't know about federal court. I don't know if that's ever happened to me, but.
Well, I think we could talk about this all day. But why don't we close it out? If any of our viewers want us to continue on this, I don't know. I find it kind of dry. I mean, I'm an attorney, so I find civil procedure fascinating. But that's me. I can read about procedure all day, and you probably can too, Yolie. I don't know, but I think we've kind of. If our viewers want us to do more on this, let us know when there's an answer, a motion to dismiss. If you want us to cover it, we'll do it. If you think we've done enough, that's fine. Yolie, what are your closing thoughts today? I didn't do viewer comments because I've been kind of under the gun with some other stuff going on professionally lately. So I didn't pull viewer comments. We'll do it next time. I apologize. But what are your closing thoughts, Yolie?
That this is my alley. This is where my alley. This is where this is my thing. This is what I used to do for a long time, is sue public entities for usually crimes. The underlying incident was a crime. So I'm interested in this, and I don't know how strong this lawsuit is. It may not be that strong, but I'm going to follow it. So if we don't follow it on here, I'll follow it. But
okay, Yolie has her own channel.
Yeah.
Be sure to subscribe to my channel, but go over to Yolie's channel and subscribe to her channel. She does some really interesting stuff, and it's not as long-winded as my channel. So my closing thought is kind of the same, but based on the law that we went over, the Barlow case, I think that the plaintiffs have a tough row to hoe legally. I'm not talking about, whether it's right or wrong. I'm not talking about, do I have a lack of empathy for these people? I'm hesitant. I'm hesitant to make my final comment, but I'll make it anyhow.
Do it.
What?
Do it.
We get accused of being grifters. And Laney Law will confirm that when I first started doing podcasting, I did it for totally different reasons. I didn't even know you could get paid. but you can get paid. And as Mark Meadow one time said, when he was on our channel, he said, well, we're part-time grifters. So we get accused of being grifters, but I don't go to federal court seeking a payday over there. So that's my final comment. Read into it as much as you want or as little as you want. Comment down below. Let me know what you think. And oh man, Yolie, final thing here. What kind of an emoji would we have people drop? If you've been with us through this whole episode, drop us an emoji. But Yolie, which one?
I don't know, something about universities.
A school, a university. If there are no university buildings, how about anything to do with school? A pencil, a pen, a tablet, a blackboard, anything.
Yeah.
All right, Yolie, thank you.
All right, thanks.
Have a good one, and don't forget to subscribe to both of our channels.
You pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.